first case is State of Ohio versus Darodd, Lenell, Paige. We do not have an appellee arguing today, just the appellant, so you'll have 15 minutes to present your argument. The arguments are being recorded. When you present your argument, please introduce yourself, keep your voice up, and remain behind the podium. You should not use the name of children, minors, and victims during your argument. You can refer to them by terms like the child or initials. We've read your briefs and are ready to proceed when you are.
Thank you, Your Honor. May it please the court, Andrew Karras on behalf of the appellant, Darodd Paige. This case, we've raised the following questions. Did the trial court have the authority on the eve of Mr. Paige being set to leave incarceration to correct its flawed imposition of post-release control? If so, if the trial court did in fact have that authority, did it utilize the correct procedures in doing so? And 3, given the errors in the initial imposition of post-release control on Mr. Paige, and given that those errors were to the detriment of either party on either side of the V, was post-release control imposed at all? I submit that the answer to all of those questions is no, and accordingly we would ask this court to reverse and vacate with instructions to vacate any putative supervisory portion of Mr. Paige's sentence.
So you're asserting that there's no PRC whatsoever, even discretionary here? Or, because my understanding is it's discretionary versus mandatory, right?
Sure. So what happened at the initial sentencing hearing was at the sentencing pronouncement that the trial court gave Mr. Paige was that he would be subject to post-release control up to 3 years at the discretion of the parole board. So that was an error. That's not what a violent felony 3 offender is subject to. And that was to the detriment of the state, and under current case law, that means the state had to, was the aggrieved party and would have had to appeal that to challenge it. Now, on the other hand, when the trial court journalized post-release control, what it did was impose a temporal period, a term of post-release control consistent with a felony 2 offense, which is a minimum of 18 months supervision and a maximum of 3 years, the term at the discretion of the parole board within that range. So that error was to the detriment of my client, obviously, in that it imposed a greater minimum term of post-release control than he was statutorily subject to. So I submit that that is what kind of places this case outside of the framework contemplated by Bates and Harper. In Harper, the Supreme Court kind of moved us on from the regime of PRC errors being void rather than void, or moved us past the void world and into kind of this brave new voidability world, whereby failure to challenge a post-release control error that aggrieves you makes that error subject to res judicata principles. The problem in this case is, the case law also tells us that while trial courts generally speak only through their journal, post-release control operates as something of an exception to that general maxim that both the oral pronouncement as well as the trial court's journalization of what it tells a client or a defendant at a sentencing hearing, those are both critical aspects of the sentence.
Let me ask you this, and I'm going to call this the decision that took place to sentence initially in October of 22 was the first decision, and now our second decision is the one that's on appeal now, this decision made after the court set this hearing. So you, as I understand, we appealed the second decision as I look at the docket, and no one has appealed that first decision. So how do we have any authority to do anything about the first decision today? We can certainly say, you're right, they're there in the second case, remand, but why would we do anything about the first decision when no one, you didn't try to file a plain appeal, you didn't say also review that decision and see that it's wrong?
So I think that's correct in that, like, what this court can't do is change the sentence that was initially imposed. What I think it can do is clarify what the sentence imposed actually was, and that
Well, that's not being appealed. When all this being appealed, did the trial court correctly modify its decision in October of 24, the second decision, Why are we going back to the first decision?
Certainly. So, in a sense, what our position is the language in that, the supervisory component of his initial sentence is essentially a nullity because, again, the pronouncement and the generalization were flawed in different ways.
But I appreciate what you're saying. I appreciate that part. But would you have had to appeal that decision at some point for us to have jurisdiction to review?
I think Harper and Bates generally say that the aggrieved party does have to appeal, lest that sentence be subject to res judicata. Why I think this case isn't squarely captured by the rule in Bates is it's not really clear who the aggrieved party from that original sentence was. So I don't know whether that means that I'm in a jurisprudential sense, I don't know whether I'm framing this as an exception to the voidability rather than voidness doctrine, or if I'm essentially saying that irreconcilable errors in the imposition of PRC means no PRC, ab initio.
Did anyone in the hearing in front of the trial court on the second case, did the defendant raise the objections you were talking about to notice? Did they raise the objection that this statute doesn't permit what you're attempting to do, judge, and you can't do it this way?
They did not. I think to be sure, they did not. So
why would this then not be plain error analysis, which I don't recall you making?
So it is a question to the court's jurisdiction. I think that's something the Baker case in the 8th District says. Whether the court has the ability to convene a 2929 1.191 hearing is a question of jurisdiction. So I would submit that it's just not forfeitable in the way other issues are for that reason.
The court is correcting. It seems to me the court was attempting to correct their oral statement that they made at a minimum, that they initially advised him this is discretion, not me. And wouldn't 292919 permit the court to do that? If they don't tell someone PRC will be imposed, they have the authority to have another hearing. If they notify them correctly, do all the things they're supposed to, they have the authority to make that determination.
So a couple of things, and I'm going to start with a point that, to be clear, I haven't explicitly raised in my brief, so I'll concede that. But there is some statutory language in 292919B2D that suggests that the application of 2929.191 is actually much narrower than that. It applies to a much narrower range of defendants. That is, people who were sentenced prior to its operative date, July 11th, 2006, but then who have these hearings prior to.
Well, right. We have A and B are for people prior to 2006, and C seems to say for people after, anything you could have done in A1 and B1 you can do, but you have to have these hearings.
So I think that's one understanding of it, and that's certainly the understanding that has been applied. I think there is another textual understanding, at least, that this just does not apply, this procedure does not apply to people whose sentences are rendered after July 11th, 2006 at all.
And how would a court, if that's true, how would a court ever correct these errors when they come up? Because unfortunately, judges are human, not unfortunately,
certainly,
and they make mistakes. That's going to happen from time to time, and this statute recognizes that.
So I don't have the answer to that. How would they ever? I think in what's clear, in appropriate circumstances, if the oral pronouncement at sentencing is correct, but the generalization is flawed, there's still authority to issue non-protunct corrections because those corrections are regarded as clerical in nature. If you have the opposite situation, what procedure is there? I don't have an answer for that. But I don't necessarily think I need an answer to that question in order to be entitled to the relief.
We may want to have one, which is why I'm asking you that.
And I think it's probably
I appreciate you don't have to have an answer for us, but.
And it's probably an area that's ripe for some intervention by the General Assembly. I think that's correct. Turning to an argument that is kind of more squarely raised in our brief, as to does 2929.191 apply? I think the answer is no, just given the categories of offenders it applies to on its face. So the Baker decision as well as the Tolson decision, we've cited both of those in our brief, tell us that that statute applies to offenders who've not yet been released from prison and who fall into three categories. those who didn't receive notice at the sentencing hearing that they would be subject to PRC, those who didn't receive notice that the parole board could sanction them with a prison term up to half the term of their incarceration, and 3, those who didn't have both of those statutorily mandated notices incorporated into their sentencing entries. No, Paige doesn't comfortably fit into any of those categories, I would submit. He clearly doesn't fit into the category of offenders who aren't given notice of the parole board's authority to sanction. That notice was articulated in the sentencing hearing. It was incorporated into the sentencing entry. I don't think he comfortably fits into the category of offenders who were not informed of the term or potentiality for PRC, because he was told those things, and those things were memorialized in his sentencing entry, albeit incorrectly. And so, 2929.191, it is a penal statute. I think it has to be construed accordingly. For that reason, I would just submit that he is just not the sort of category of offender to which the statute applies. Setting that aside, and turning to what you hinted at, we've also raised a challenge to whether the trial court complied with the notice requirements of the statute. Again, I submit a penal statute and should be accordingly construed strictly. Under the statute, the defendant has to be informed what the purpose of the hearing is. Here, the scheduling order is not especially expository. It just says the matter is hereby set for a post-release control PRC hearing. As some evidence, not that this is dispositive, but I think it's certainly strong evidence that this was inadequate notice of the purpose of the hearing. Paige was, as demonstrated by the sentencing transcript, confused about why he was there. Just turning to some of the, the court informs Mr. Paige at this October 16th, 2024 hearing that his parole period is mandatory. It's not discretionary on the part of a parole board. She asks, does Paige understand? At which point he asks to speak with counsel. There's a break. They go back on the record. The court asks counsel, does he understand why we were back in court? And counsel responds, absolutely not. At that point, there's some back and forth over whether Paige, his understanding as to whether his agreement to a term of PRC was necessary as part of his plea bargain, whether he was subject, there's some conflation between the concepts of community control and post-release control. As some evidence that the notice did not reasonably appraise him of what the purposes of the hearing was. He was very confused about what the nature of the hearing was.
You mentioned the plea agreement. I don't find that on the record. Am I missing that? Is that on the record somewhere to your knowledge? Whatever plea agreement he signed when he was sentenced?
So I don't know if there was a written plea agreement. It certainly doesn't appear in the docket.
He referenced it, and I went back and couldn't find any written plea agreement in the docket. So to your knowledge, and also you would agree it's not in the docket anyway.
So there is some agreement, or there's an oral recitation of what the agreement is at the sentencing hearing, which is included. That transcript is included.
If in this case the trial court usually has someone sign a written agreement that is supposed to lay all that out, if that happened, it's not in our record before.
That's correct, and I don't think there's any indication that did happen. That there is a written recitation of rights and a written notification of what PRC would be. I don't think that appears in this case. At this point, I see that I have about a minute and 30 seconds left of my time. I would just say that this case, as for the reasons we've been discussing, I think is unusual. There's precedent that explains that flawed generalizations that precede correct sentencing pronouncements as to PRC are subject to clerical correction by the court. The current precedent is that flawed imposition of PRC generally must be challenged on direct appeal by the aggrieved party. Again, determining who that aggrieved party is here is difficult to do. I submit that the application of res judicata principles doesn't provide an adequate answer because under Harper and Bates, both the state and Paige would have been required to correct those variously flawed pronouncements. Neither party did so, and so I would submit under the unique circumstances of this case, PRC was never in fact imposed, we would ask the court to reverse and remand, vacating any putative supervisory portion of the original
I
sentence.
have a question before you
Sure.
conclude. Is your client currently released?
He is.
And is he on PRC?
He is.
And how long has he been on PRC?
So he was released, so he was he was recommitted after his initial release to the Department of Corrections following his accrual of new criminal charges, I believe non-felony in nature, but a new misdemeanor domestic violence, charge. I don't think there's any specification, at least in this record, of when that happened. I don't know exactly when he went in, but it was toward the end of July that he was let out of the Department of Corrections as part of, after serving his parole sanction.
Well, as a mootness question, though, he is still on PRC and serving.
He is
some
correct.
sentence.
He is, yes. And I think, in previous cases, courts have taken judicial notice of, whether someone is in DRC custody, and I believe the website indicates that he will remain on PRC until 2028.
Did anyone move for a stay of that portion of the sentence?
No. Right. Thank you, Your Honor.